2, 1.
Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner. And on behalf of Judges Stafford and Armstrong, I'm pleased to welcome Mr. Beavers and Mr. Miller to this oral argument, which we are live streaming for public viewing. Of course, the argument will also be recorded and available to the public and the parties at a later date. We will conduct the hearing in the same fashion as if we were all in the courtroom together. Each side has 15 minutes, and the appellant has already informed Mr. Hibner of the amount of time to reserve for rebuttal. Unless there are any announcements, I'll ask Mr. Hibner to call the case.
Kelly Turner et al. Versus WW Steeplechase LLC et al.
Very good. All right, Mr. Beavers, you have the floor.
Well, thank you to the court for taking the time to hear this morning. I am Chris Beavers. I represent Kelly Turner and Justin Turner relative to an accident which occurred back on February 14th at the Steeplechase apartment complex. I'm going to focus my argument today on the issue of constructive notice, as was indicated by the trial court, and I think basically agreed to by the parties. I mean, constructive notice is the key issue relative to this case. So I'd like to first briefly go through the facts associated with the case. I know they've been outlined in the brief, but very quickly, Kelly Turner was living at the 4407 unit of Steeplechase Apartments. She was in, well, the top floor of that particular unit was the master bedroom, which had one singular floor vent. Unfortunately, the floor vent was actually smaller than the hole in the wood that was below the floor vent. It was only being held up by carpet. So unfortunately, one day as Kelly Turner was vacuuming in her apartment, she steps backwards, steps on the floor vent. It collapses. Her foot goes through. She becomes injured, which leads us here today. A few days after the accident, we had an expert go over and do some measurements and determine what actually occurred here. That's the Coons affidavit that you've had a chance to review. Mr. Coons took measurement of the vent. The hole below the floor vent did confirm that the sizes were such that the floor vent was only being held up by carpet. And then Mr. Coons also indicated that, you know, this situation was similar to basically having a concealed hole that was in the floor of the apartment, since it could barely hold, the floor vent could barely hold the weight of the vent, much less the weight of a human stepping on it. He blamed the particular issue on, well, both the negligent, construction of this particular situation, but also on the negligent maintenance of this situation. Certainly, in this case, SRA management did not construct the issue, but they did maintain the property. Mr. Coons further in an affidavit indicated that this is something that should have been discovered during the regular course of maintenance that a reasonable landlord would have gone through. And I guess of note, this appeal today is just relative to SRA Management LLC. There was a previous summary judgment for Steeplechase, but I mean the issues are identical, but this appeal only concerns SRA Management. No, there was some discussion of that in the brief. After we had the inspection with Mr. Coons, we also had the chance to speak to Tony Manos. Tony Manos was the maintenance manager for this particular property for approximately 4 years. He indicated a lot of interesting things, I think, that are very informative to the case. Particularly, Mr. Manos, when he was first asked about it, indicated that the carpet in this particular unit, 4407, had been changed while he was there working for Steeplechase at this particular property. Now, he later on changes his mind and says something different, but we're here on a motion for summary judgment, so these facts must be interpreted in the light most favorable to the non-moving party. And he did say, when he was first asked about it, that the carpet had been changed. He indicated that these floor vents should fit snugly into the hole. He said, like a square peg, that he would have been able to figure out. In fact, he said you would be able to figure it out if the hole below the vent was not the proper size. He indicated a number of occasions where they had to actually take the vents out. They would have to take it out when they commonly had complaints of heating issues in these units, which were very common. He indicated that they would take it out when they did their turnovers. He was specifically asked, when do you take it out? He said, when we do our turns. And then more specifically indicates that they would take it out because when they would have to remove trash, which obviously brings up that in order to look for the trash in the first place, you would have to pull up the vent, or at least move the vent somewhat. And he indicated that if you did those things, you would be able to tell if the hole below the vent was bigger than the actual vent. He indicated that.
Mr. Beavers, let me ask you a question. Other than the initial indication that he said they had changed the carpet out and then he changed his testimony, was there any indication that that particular apartment went through any of the things that you've just mentioned? Any changing in the vents or anything like that? Were there any maintenance records that indicated that, or testimony that indicated that?
There were not maintenance records indicating that it specifically went through a changing of the vents, but he went through the procedure that they went through every time they did a turnover. And one of the procedures was they would check for trash, which required looking in the vents. So, I mean, I think he did indicate that. I wish it was a little more specific.
Let me follow up with that. And what does that mean, looking for the trash? What did they specifically do?
Well, he specifically indicated that, if there's garbage down there, I asked him, if you're going to remove a vent to check air, would you ever remove it for any other reason? And he said, if we do our turns, if there's a bunch of trash, like I said, that's down there, we remove it out there, clean it out, and put them back in. So obviously they have to find out whether there's trash down there in the first place, which means they're going to have to pull up the vent. I wish he'd been more specific about it.
Right. Let me follow up with that. So do they do that every time that there is a turnover in the apartment when a new renter comes in?
I think that's the only way to interpret the answer, and that's on page 35 of his deposition. I asked, is there any other time you remove the vent? And he said, if we do our turns. He didn't qualify that sometimes they do it. He said, whenever they do their turns, which their turns means when they do their turnovers between tenants.
You just used the word if. Does it mean that they do them sometimes, or are they required to do them every time there is a turnover? I mean, is that the policy of the apartment complex? I'm trying to get as specific as I can here to figure out exactly what the testimony was and what the policy is.
Right. There was not any testimony about the particular policy of the apartment complex. The testimony was just about what they did. And I mean, I think the only way to interpret it when he said, if we do our turns, is that, whenever they do their turnovers, that this is something they're doing. This is something that they're checking. They may not have to remove trash every time, but they have to check for trash every time.
Okay.
And so in any event, thank you for your question, Your Honor.
And Mr. Beavers, when you say turnover, are we referring to one tenant leaving and a new tenant renting the space? Is that the turnover we're talking about?
Yes, that is. And earlier in the deposition of Tony Manos, he specifically kind of defines what he's referring to as turns. But the turn is when one individual moves out and somebody else moves in. That was it seemed like the main part of his job was turning these over, getting it looking clean and new for the next individual that moves in. So that was what he referred to as a turnover. That's correct. And then, I mean, quickly, when the court actually decided this, the trial court decided this issue, the trial court analogized it to the Parker case, which was previously decided by this court. And the Parker case was the one in which there was a defective shower bench that collapsed. And the ultimate issue in that particular case was that the court ruled that the the efforts that would be required to actually figure out that that particular shower bench was defective was far beyond what would be required of a reasonable landowner, i.e. you would have had to take out sheetrock and look behind there, and that was just simply unreasonable. I would note that that case had actually been decided in the opposite manner in the appeals court, and so it was certainly not a close case one way or the other. And this case we have here today is really a polar opposite of that case, where all you would have had to do was actually less than the trial court indicated. The trial court thought you would have had to pull back the carpet, but as we learned from Tony Manos' deposition, all you would have to do is either to pull out the vent or to somewhat move around the vent in order to figure out that this particular issue was there. I think that this case is really kind of the perfect case that hits all the issues in the Lethco exception. When we know this was something that existed at the time at the time that the Turners moved in. This is something the landlord could have found out about through regular maintenance. We have proof of that. And this is something that obviously, a tenant wouldn't know about by just looking at it, but it is something that a landlord could have found out about. And indeed the landlord should have discovered in the exercise of reasonable maintenance.
Thank you, Mr. Beavers. We'll now hear from Mr. Miller.
Good morning. May it please the court. Your Honors, this case is about one issue, and that issue is what is the duty of a landlord to find an unseen and undetectable dangerous condition on a leased premises. This court has answered that question time and time again. The rule is, and I'm going to quote from the Lethco decision, generally, a landlord is not liable to a tenant or a third party for harm caused by a dangerous condition on the leased premises. This court has also previously held that a landlord is not an insurer of the safety of the leased premises. And most recently, Judge McGee, in the Fisher opinion, stated that the law does not place upon the landlord the obligation of an insurer or warrantor by contract, nor does it impose the extreme duty of constant care and inspection, but only reasonable care and diligence. And like reasonable care and diligence are required of the tenant. So, Your Honors, under this precedent, the trial court correctly granted summary judgment to SRA management. Now, as an initial matter, there was another party. They were included on the notice of appeal. That party is WW Steeplechase, LLC. I think as Mr. Beavers conceded, they're not part of this appeal, and no appeal of them would have been timely. So I'll go ahead and move on and specifically just address SRA management. Now, as previously noted, the general rule is that a landlord is not liable to a tenant or third party for a dangerous condition on a leased premises. There is an exception to this general rule of landlord non-liability. The exception has three components. The first component is that a dangerous condition must exist at the time the lease was executed. The second component is, of course, constructive notice. The third component is almost like a reverse constructive notice. That is, that the tenant did not have constructive notice of the dangerous condition. Now, so I would somewhat disagree with Mr. Beavers that the sole issue is constructive notice. I think it's each of these three elements, and I'm going to address each one in order. And just again, all three of these elements must be satisfied to avoid that general rule of non-liability. And the appellants have not met the exception in this case. Now, first is proof of the dangerous condition upon execution of the lease. This is the evidence that is in the record points to the fact that it might not have been there at the time of the lease. The truth is we simply don't know. But the evidence that's in the record. Let me ask
you a question, Mr. Miller, before you get too far into that.
Yes, Mr. Steff.
So
Judge Steff.
What does the record reveal about the inspection that would be made when a new tenant took over the apartment?
So there is one record in the appellate record that indicates what Mr. Manos did when he did his move-out inspection, but I don't know that there's anything in the record that signifies what specifically was done prior to the appellants moving into this specific apartment. And Your Honor,
Okay.
if I could
Well,
go.
let me try to be a little more specific for you. Was there an inspection done, as Mr. Beavers has submitted, that the vents would be checked for trash?
Yes. So, Your Honor, there is always an inspection upon move out of a prior tenant and before another tenant moves in. The trash component aspect that Mr. Manos testified to, it's kind of interesting the way you asked it. The answer to your original question to Mr. Beavers was no. There is, when you check the trash, as Mr. Manos said, he's talking about looking. You would look in the vent. There was no testimony that you would remove the vent to check for trash. There was no testimony by Mr. Manos that he removed the vent in unit 4407 of the appellant's apartment prior to them moving in to check for trash. So there was no testimony at all as far as removing this vent. And that's one thing that's somewhat misconstrued about Mr. Manos' testimony, is that he testified that you could tell if it was the hole underneath was too big, if you took it out, if you actually physically removed it or was replacing it. But there was no testimony or evidence in the record that that was actually done prior to the appellants moving in or ever done by SRA management. And so that's the important part of Mr. Manos' testimony that was really left out.
What about the replacement of the carpet? That should have revealed the size dilemma.
Right. Now, Your Honor, if you read Mr. Manos' testimony, he estimates the age of the carpet in the appellant's apartment was 5 to 6 years old. SRA management had only been operating this specific apartment complex for approximately 4 years upon the move out of the appellants. So that Mr. Manos' estimated age would predate SRA of the carpet, would predate their operation of this unit. Now, there was some argument that he changed his testimony, but what I think he's really referring to is that the carpet had been changed since its construction many years prior. There were some units that still had the original carpet when the apartment complex was constructed. That had been changed in some units. But in this specific unit, 4407, Mr. Manos estimated that the carpet was 5 to 6 years old, which again would predate the appellee's ownership and operation of the complex. So I will jump back briefly to the first element of the exception, which is that it existed at the time of the execution of the lease. The evidence is that the appellants completed an inspection form upon move-in that was required under the lease agreement. This inspection form had a line item for bedroom AC vent. And as your honors can see from the record, that was marked through by the appellants, signifying that there was no problem with it upon move-in. The other evidence is that they lived there for 11 months prior to this occurring. And there's another case, Fuller, I believe, decided by Judge Armstrong, in which a railing had broke. It was a landlord case. The railing had broke. They had also lived there for 11 months. And some of the analysis was the fact that they lived there for 11 months negates the fact that this may have existed at the time of their move-in and just somehow was dormant for months or years prior to this event. Now, the second element is, of course, constructive notice. There's no dispute that SRA management did not have actual knowledge of this condition. The focus of Judge Davis's analysis at the trial court was constructive notice. And two of the facts that Judge Davis really took notice of were as follows. One, it could only be seen that it was dangerous really by pulling up the carpet, or later, Mr. Manis' testimony was after summary judgment, and then it was brought back before Judge Davis on a motion to alter or amend. So the first fact it was only visible really if you pull up the carpet and look. And the second fact that Judge Davis really looked at closely was that the plaintiff's engineer expert stated that it was an unseen and undetectable condition in his expert report. Now, we would dispute that he has the credentials to testify on what a reasonable landlord would do as an engineer. And Judge Davis didn't give him any credence to that effect. But what she really took notice of was that the expert said it was unseen and undetectable. I think at one point during oral argument, she stated that your own expert says it's unseen and undetectable. How could there be constructive notice? And that's what I think is important. And that led to her analysis to the Parker case. Now, in the Parker case, it was a shower bench and the defective condition was behind some sheetrock. In this case, it's carpet. And Judge Davis conceded that carpet you would have to destruct less by pulling up carpet. But I think the analysis is spot on that, look, in Parker, you had to remove sheetrock to find the defective condition. Here it's the carpet, and that there's no duty on a landlord to go on a fishing expedition to pull up carpet to find this dangerous condition that may not exist. There was no evidence that this might have existed prior to this incident. There were never any other falls or defective AC vents in other units at this apartment complex. And the appellant's own inspection prior to move-in didn't reveal any problems. And so following that analysis in Parker, the court granted summary judgment. The court also compared it somewhat to the Smith versus Kastner-Knott case. That involved a ceiling tile that fell on a young girl and injured her in a store. And in affirming summary judgment in the Kastner-Knott case, it was the court discussed defective construction, which may have been the cause of this, may not. The truth is we really don't know. And in that case, in Kastner-Knott, it was that a property owner is not responsible for defective construction unless they knowingly accept that defective construction. And that's clearly not the case here, as SRA management came to own this property years after it was originally constructed. Now, I do want to address the third point briefly, and then I'll move on to the second issue on appeal very quickly. The third issue is that the appellants don't have notice. And I can't argue that they do, that they knew about it and still stepped in it. I don't know that. That's not in the record. But what I will argue is that they had the most opportunity to learn about this defect, if anybody did, despite its hidden or unseen and undetectable condition as stated by their engineer. And the important thing is that they lived there for 11 months and they marked through it on the inspection form when they moved into the apartment. And so I think that third element of the exception is also not met here. There was also one anecdote in the Lethco opinion that I think is applicable here, and that's what happens if the parties have equal knowledge of a dangerous condition. In this case, there is equal absence of knowledge. Neither party knew about this condition, And in the Lefkoe opinion, they state as follows. When a landlord and a tenant have coextensive knowledge of the dangerous condition, the landlord is not liable to the tenant or the tenant's employees for injuries sustained as a result of the dangerous condition. And that's really the case here. The parties had coextensive knowledge and really a coextensive absence of knowledge. I would direct the court to the Fisher v. Villages at Henley Station, decided by Judge McGee, and the Fuller decisions. They are very similar. Fisher was actually decided in January 2020 after this case was originally decided on summary judgment. And the last point I will make is on the second issue, and that is the negligence per se claim. The plaintiffs were allowed to amend to add a claim for negligence per se. They cited the statute, but never attached not the statute, but the building code and the ordinance. They never attached that. They referenced it as required by Rule 8.05 of the Tennessee Rules of Civil Procedure. That is not a matter outside the pleading. Even if it was, it would really be harmless to analyze it under the standard for motion for summary judgment, because the trial court found there wasn't a duty or there wasn't a actual claim under 12.02. So under Rule 56, the result would be the same. Thank you.
Thank you, Mr. Miller. Mr. Beavers, your rebuttal. Please unmute. There we go.
That would have been a quiet rebuttal. Thank you, Your Honor. I think the primary issue in this case, I think why I find error with the trial court's decision, is that I think the facts in this case were not analyzed in the light most favorable to the non-moving party. I think if you look at them in the light most favorable to Kelly Turner and Justin Turner, this is a matter which needs to proceed to trial. This is not something that was appropriate for summary judgment dismissal. I think one of the most, as was touched on earlier, I think one of the most key issues in this case is the issue about the carpet. I would submit that if the carpet in this particular property had been changed, then this case must be reversed. If the carpet had been changed.
What does the record reveal about that? You indicated earlier that the maintenance person said carpet had been changed, but then he subsequently either recanted or explained that testimony.
Right.
What do you think it reveals?
Right. So on page 20 of the deposition of Tony Manos, I asked him, had you changed the carpet before in this particular apartment? He said, well, it was brown carpet, I remember. So it had to have been changed because the original was white, like cream colored. And I followed up. Okay, so when you say it had been changed, you mean it had been changed since you had been there at Steeplechase? He said, probably, yeah. And I said, okay. And then he said, I would say it was, less than 10 years old for sure, maybe 5 or 6. And then I asked him later on, when did you start working at Steeplechase? He said 2014, maybe, or 15. Then he said it was July of 2015 to May of 2019. And earlier in his testimony, was indicated he didn't work there for different companies. He worked there when it was the Steeplechase company that is the current defendant, SRA Management being their management company.
He works for SRA, right?
Correct.
Okay.
So he worked while it was this particular defendant, not a previous individual that owned it. And he said that the carpet had been changed while he was there. And I mean, later on in his testimony, he indicates that, well, maybe it was changed prior to me getting there. But when he was first asked about it, he says that it was changed while he was there, that he specifically knew because it was white when he got there and it was brown. And it was brown at the time the accident occurred. So I think that's very important to look at. If that's analyzed in the light most favorable to us, I don't think there can be any other decision other than they should have had constructive notice of this. There's been some issue made by the defense about whether or not this issue existed at the time these individuals moved into this townhouse. I think this case is totally different from the Fuller case that was cited, or the Fisher case that was cited, wherein those were talking about stairs, something that you're walking on several times a day. It's possible that a stair could come loose over a period of time. That may be something that didn't exist at the time the lease was initially entered into, wherein what we're talking about here today is a vent and a wooden hole below the vent. The vent's not going to change in size unless the vent were changed out, in which case they would have had notice. The hole is not going to.
Beavers, let me ask you, did your expert opine on Mr. Manis's testimony about it appeared that the vent had been pushed through the floorboard, and that may have been done by your clients, who supposedly also perhaps damaged the apartment upon moving?
No, the expert did not give any opinions after the deposition of Tony Manos. So there was nothing where the expert interpreted that particular thought.
Well, at the time that your expert examined the vent and the floorboard, had the carpet been removed?
No, when the expert examined it, it was 5 days after the accident. It was still in its original condition.
So the carpet had not been removed? Is that
Right, correct. The carpet had not been removed at that point in time. The carpet was still there. He did peel it back to look at it, as
So
indicated.
he would not have been able to see what happened to the floor underneath the carpet, as Mr. Manis testified about?
Well, I mean, he could look down into the hole from both the top and from the bottom and see what had occurred. So, I mean, he was able to look in there, and he was able to peel back the carpet and look at it. He actually took a lot of very good detailed pictures and measurements relative to it.
Okay.
So I think that's something he was able to look at quite well. And I guess that's my time. Thank you all very much for taking time to listen.
With the indulgence of the presiding judge, let me ask one more question.
Okay.
And that's this. Were there any records, maintenance records, policies, procedures, anything like that, as far as checking the apartments out in between tenants moving in, moving out, that indicated that an inspection was actually done, and that the inspection possibly could have revealed or would have revealed that there was a problem with this vent? We've kind of danced around this issue, but I'm trying to determine if there was a definitive determination ever made.
I mean, I think that's something that's open to interpretation. There's not something I'm going to tell you was definitive. I think if you interpret the facts in the light most favorable to us, then I would say yes. Mr. Manos said that upon every turnover, they looked at everything, and I specifically asked him if one of the things they looked at and examined on every turnover was the vents, and he said yes. I think that was my last question in the deposition. And he also said that, if the situation existed where the hole was bigger than the vent, I asked him if he would have been able to tell that. Not if he would have been able to tell when he removed it, but if just he would be able to tell in general. He said yes, he would be able to tell.
Okay.
Is there any evidence that the maintenance company would lift the vent to look for the garbage and debris versus just looking through the vent?
That's not in the record.
Okay. All right. Thank you. Any further questions from the panel? Hearing none, thank you, Mr. Beavers and Mr. Miller, for your arguments. We will take this matter under advisement. Mr. Hibner?
This honorable court is now in recess until 10:30 a.m.
Thank you. And counsel, you may exit the meeting.
Thank you, Your Honor.
Hey, have a good morning.